Add perspective to these cases is trial attorney Sarah Becker from the Atlanta law firm of Aurora and La Scala. Thank you for joining me again on the desk this morning, Sarah. Speaking to members of the community and also seeing social media comments online, I'm hearing from a lot of men who are just kind of freaked out about past transgressions, appropriate workplace behavior now, and what they can or cannot do, how to read the signs and how to behave. What are you hearing from people now?
You're spot on with what you're observing. It is a nervous climate right now when it comes to what conduct is acceptable and what isn't. And part of that is probably because there's no black and white answer to that question. Legally, any sexually motivated conduct that has the effect or the purpose of intimidating or harassing another person it can be classified as sexual harassment.
Some of these incidents are clear-cut. Men exposing themselves, that's clear-cut. Right. Sending a sexual toy to a coworker, that's pretty clear-cut. But there's some other behavior that I'm hearing about that people are not so clear on. Is it okay to flirt in the workplace? Is it okay to put your hand on another coworker's arm or shoulder?
Right, and that's the question. When does the behavior cross that line from appropriate kind of natural social interaction to sexual harassment? And that's going to have to be analyzed on a case-by-case basis. It's factually specific. So if it's ongoing conduct, and if someone has made you aware that they don't want it to happen, that's going to be more likely to be considered sexual harassment.
Does this come up in cases many times where because a woman has not said anything to the person being accused, that becomes an issue? Absolutely,
because a key element of making it sexual harassment is that it's unwanted. And the first step in proving that the conduct is unwanted is saying something to the person who is engaged in the conduct.
All right, so Sarah, I'm hearing from people online, but also Liza Lucas is hearing from some of our viewers online as well. So let's turn to her. Liza, what sort of questions are people wanting answered this morning?
Well, you clarified one of them just now, and that is what exactly qualifies as harassment. But a lot of you have been chiming in. We've had tens of thousands of hits on this comment. And one of the things that has been really noted by Hattie, we want to show her question right now. She's asking about privacy. When are these women coming out? Why ask for their privacy? And I think that's something that comes up a lot when we deal with high-profile cases, especially with sexual harassment. Maybe you can clarify the privacy of the victims and why that's important.
It's incredibly important, I think, because by the nature of the accusation, these are very personal situations, right? It's not stuff that you don't want to engage in it in the workplace. You don't want to talk about it publicly. And it's an impediment to victims taking that first step that we just talked about, that important step of telling the offender to stop. And if you don't do that, and then you don't report it to the employer, you're really going to have a hard time going forward with any legal claim.
Sarah, must you always come face to face with your accuser? Is that always the case whenever you're filing a claim?
Again, there's no black and white rule when it comes to that. I would say that would be the most clear way to ensure that you have good evidence that it was unwanted conduct. However, there are going to be situations where you're not comfortable doing that. And in that circumstance, I'd say that you could also go to an employer. You could go to an HR department and probably put yourself in a good position. It would be best to, maybe both personally and legally, find the courage to say, please stop. I don't want that. It's inappropriate.
Right. Sarah Becker, thank you for enlightening us this morning. I appreciate it. Liza, thank you as well.